Hello students! Welcome to the second video lecture for Healthcare Ethics, Fall 2020. This lecture covers two essays. The first was written by Bruce Miller in 1981, and it is titled Autonomy and the Refusal of Lifesaving Treatment. It was published by the Hastings Center Report. The second was written by Thaddeus Pope. It was published in 2012 by the journal Chest, and it is titled Legal Fundamentals of Surrogate Decision-Making. You will find both of these essays and the worksheet that accompanies this lecture in the course materials folder for this week. So, I'm going to start this week's lecture by defining ethics. Ethics is, of course, in the title of our course, and it is a word that came up a whole bunch in this week's reading, and you'll be seeing it over and over again. Last week we talked about biomedical ethics and healthcare ethics. We talked a little bit about research ethics. So you know already that there are all different kinds of ethics. But what is this central word, ethics? So the word comes from Greek, and it specifically comes from a book by Aristotle, which is called, in English translation, Aristotle's Ethics. And it's a book about how to live a moral life. So Aristotle, ancient Greek philosopher, literally wrote the book on this. And that means that the discourse that we're dealing with is really old. And it deals with a lot of really big, really old ideas. Ethics, in the sense that we're using it, refers to a system of moral principles and the branch of knowledge or study dealing with those moral principles. Moral, in that phrase, moral principles, comes from the Latin word mores, which means custom. So like last week, we talked about nomos in Greek, in the word autonomy, which means law or custom or rule. The Latin word mores is a kind of similar word, and it means custom. Right? So moral actually means according to custom. And that, that's an important piece of information to know, because morals are not universal, right? They are defined by the customs of the culture in which they occur. And principle, in that phrase, moral principles, has the same root as primary and prince. So it means first. The Latin root is princeps. It means first, and also first in charge, first in order of priority. So it's a useful word to think about this week, because we've got a lot of lists, and we've got a lot of concern about which thing comes first. Okay, so ethics is about moral principles and the study of those moral principles. So in the first article I'm going to discuss from our readings for this week, Miller's article, Autonomy and the Refusal of Lifesaving Treatment, we begin by talking about one of those four big terms for healthcare ethics, autonomy. So the four terms that we're going to cover in this course are autonomy, beneficence, non-maleficence, and justice, right? So this week we're doing autonomy. Autonomy, as I mentioned last week, comes from the Greek words auto, which means self, and nomos, which means custom or law. So autonomy is self-rule. It means being a law unto oneself. So making one's own decisions according to one's own customs. We're also going to encounter a couple of new terms this week that are important to take note of. The first of them appear sort of all at once in the Miller article, and those terms are coercion, manipulation, and undue influence. And all of these things are things that interfere with autonomy. So they're all bad things. We don't like them. They're things that make it difficult for someone to make their own autonomous decision. So coercion, manipulation, undue influence, basically all you need to know about those things is that they're no good. Okay? And we're also going to talk about a couple of key terms that we've seen before that show up in the articles. Paternalism, which I talked about last week, shows up way towards the end of the article. And Miller suggests that defining paternalism as an interference with autonomy, this is a quote from page 28, defining paternalism as an interference with autonomy in one or more of the four senses might be an illuminating approach. So paternalism is one of those not so great terms, and it's not quite the same as coercion, manipulation, and undue influence, but it's related to them as something that interferes with autonomy. And autonomy, we're going to get into, is defined in these four senses, right? Another term that shows up in this article, actually in both of the articles for this week, is fiduciary relationship. And it's defined here as not just something that is a property of the doctor-patient relationship, but also involves a close friend, a parent, a spouse, a physician or lawyer, basically anyone that has an obligation to protect and advance the interests of the other. And the important thing there in that definition of fiduciary relationship, and there's like a really weird example in the text here where Miller talks about like how his brother-in-law wants to buy a really expensive car and it's his duty to prevent him from doing that. So we might read some things into that about his relationship with his brother-in-law. But what's important in that example is that it's the higher the stakes, the higher the obligation. So if it's like, advising your friend about what color nail polish she should wear, that's a low stakes decision. You might still have a fiduciary relationship where she trusts you to give her good advice on nail polish. But it's a little bit higher stakes and you have a higher obligation to your friend if you are her surrogate decision maker in a healthcare situation where you are deciding a life and death decision for her. Okay? So, fiduciary relationship is a relationship based on trust. All right, so that's enough for the sort of big picture the key terms that are not autonomy. And then another thing we're going to do before we get into Miller's article is I'm going to give you a couple of critical reading tips, just like I did last week. So a thing to know about our friend Miller is that he likes to set up conflicts, right? So the very second paragraph of the essay, he sets up a conflict between patient autonomy and medical judgment, right? So this is the second paragraph before he gets to the cases, right? And so he's setting up this conflict, and it sounds like he's telling us something really good, right? So he keeps, and throughout the article he does this, he keeps offering us answers that look like they're going to work, like they're really good. So at first he seems to support this idea of taking a hard line on autonomy. And then he's like, maybe we should defer to medical judgment, right? So this is the conflict he's setting up between autonomy and medical judgment. And he kind of presents them like they're both really viable options. And then he's like, nope, I tricked you. That doesn't work. In fact, we need to do something else, which is what he's going to do in the rest of the article. So the way you track this in the article is you should look out for some signaling phrases. So look out for words that are like, it is tempting, or at first glance, it appears. So these words indicate that what the author is saying he doesn't really support. And this is not just Miller. Lots of authors that we will read in this course do this same thing, where they tell you things that seem like the things they're going for, and then they're like, nope. In fact, I was just putting that out there in order to shoot it down, okay? So you're looking for these signaling phrases like it is tempting and at first glance, and then you can confirm that he's not really agreeing with the things that he says if you read through, he'll eventually say something like, this position is not defensible, or neither extreme position is tenable. Those phrases indicate that the things he just said are things that he doesn't agree with, and that then he's going to tell you the things that he's actually going for, okay? So I realize that's kind of difficult to keep track of, but bear it in mind, because it is a style of argument that's used in a lot of academic writing, and it's a thing that you should learn how to read for. Okay, so also notice that we've got another Jehovah's Witness in this article, and also you guys might note the lack of details in case 3. So this article starts out with 4 cases, right? Just like we saw last week, it's a pretty standard thing in biomedical ethics for articles to start out with cases. And we've got these 3 really long, involved, detailed cases. And then the third case, it's really short. And it's just this guy comes in with meningitis and he's 38. A 38-year-old man with a mild upper respiratory infection suddenly developed a severe headache, stiff neck, high fever. He went to the emergency room for help. They diagnosed him with a terrible form of meningitis. And then he's like, whoa, nope, I don't want the treatment. Instead, I want to be allowed to die, right? And that description is way shorter than all the other descriptions. And when I was reading this, I thought to myself, that's kind of weird. Maybe there's actually something more there. So what I did is I looked at the end of that paragraph. There's a little footnote, right? So there's a little number 5. And I looked at that little number 5 and I was like, I wonder if that will tell me some more. So I went to the end of the article, looked at the list of footnotes, and I saw in footnote 5 the phrase, "This case is drawn from Eric J. Cassell, The Function of Medicine," which was also published in the Hastings Center report in 1976. So then I went on the library website, I looked up the Hastings Center report, and I tried to find this article. Turns out it was actually published in 1977, which means nobody really fact-checked it. But I did find the article, thanks to the joys of modern search engines, and I learned a bit more about this case. So that's an example of a thing that you might use citations for, right? It's a way of actually using this apparatus that I'm teaching you guys in this course. Okay, so that was just a side note. Now we can get to the real stuff. All right, so the first question that I want to ask for this lecture is, why does Miller give us these cases to start out with? Yeah, it's pretty standard, but also, what's the point of them? What's he doing with them? So what he's doing is setting up another conflict. And it's really the same conflict. It's a conflict between autonomy and medical judgment. So we, as the medical professionals, he says, assume that the wishes of patients 1 and 2, in cases 1 and 2, should be respected. And it seems pretty clear, in his opinion, that the wishes of patients in cases 3 and 4 should not. There's something wrong there. There's something right in 1 and 2. We go with their wishes, and in 3 and 4, we don't, right? And so it seems like if we support the autonomy of patients in the first and second case, then we have to support the autonomy of patients in the third and fourth case. And conversely, if we support the judgment of medical professionals in the third and fourth case, then it seems like that we would have to support the medical judgments to treat the patients against their will in the first and second case, right? It's putting us in this bind. And that's sort of what the author is trying to do with these cases. And then he says, okay, I can sort this conflict out for you. So by making judgments, so the way to do this, in his opinion, is not to try to make judgments about the patient's life, but to be a bit more careful about the way you define autonomy, the way you define the patient's ability to make judgments about their own life. So he says on page 24, the thrust of placing the patient's right to autonomy in the forefront of medical ethics is to counteract just that tendency to secure those decisions for the patients that are appropriately theirs. So his wording is a little tricky here, but what he means is it's supposed to counteract our tendency as medical professionals to think we know better, right? So we have to go with autonomy, but we don't have to go with this hard-line definition. Instead, what we have to do is redefine autonomy a bit more clearly, and then we'll know when a patient is actually making an autonomous decision and when they're just making something that appears to be an autonomous decision. Okay, so his way of resolving this conflict is to define autonomy in greater detail. So now we come to the important part of the essay, the reason you guys are reading this. So he gives us these 4 senses of autonomy. And what he's doing here is he's defining and clarifying one of our big key terms for the course. So you probably want to start with the definition that he gives right before he goes into the term breakdown. So on page 24, on the left-hand side, he writes, "The right to autonomy is the right to make one's own choices, and respect for autonomy is the obligation not to interfere with the choice of another and to treat another as capable of choosing." So let me read that for you again because it's super important. Okay, this is a general definition of autonomy before he gets into the specifics. The right to autonomy is the right to make one's own choices. And respect for autonomy, which is what is required of a medical professional, respect for autonomy is the obligation not to interfere with the choice of another and to treat another as capable of choosing. Okay, so what does that mean in specific? So he gives us these 4 senses of autonomy. Autonomy as free action, autonomy as authenticity, autonomy as effective deliberation, and autonomy as moral reflection. So the first one, autonomy as free action, is about the ability to act on one's own, free from coercion, as we talked about earlier, free from external constraints. So the key terms here in the definition are voluntary and intention or intentional, to do something with your own intentions. These are the good things. The bad things, again, are coercion, duress, undue influence. These are all words that are about the influence someone else or something else might have upon you that prevents you from making a decision all on your own. And another key term that shows up here is informed consent. It's something you guys are going to be talking about a lot. It's the thing you're going to be doing your projects on. So what's important in terms of free action is that the consent part of it is what goes with the free action. So free action basically means that you are doing this on your own, right? That no one else is forcing you to do it. And that doesn't require information necessarily, but requires that you give your consent and that you are capable of giving your consent, that you are capable of agreeing to something or not agreeing to it. Okay, so that's free action. The second term, the second version of autonomy is autonomy as authenticity, right? So the contrast of authenticity is inauthenticity or inauthentic, right? And this is defined basically in terms of this contrast. So if something is authentic, it is, as he says on page 24, consistent with the person's attitudes, values, dispositions, and life plans. It basically means, is this person acting in character? Are they acting the way that they ordinarily do? So to explain one of Miller's examples, he says on page 24, to ask of a person who customarily drinks beer, "Are you sure you want to drink wine?" is to make very much of very little. So this would be an example of a person who is acting out of character. So you know, your friend comes up to you at a party and they ask for a glass of wine and you're like, "Why are you being all fancy and drinking wine? Just have a beer, bro, like you normally do." So that's a person acting out of character, but it's not a big enough decision to merit this big term, inauthentic, right? So it's like a little version of what a big inauthentic thing would be. So on the other hand, if, say, you had a friend who's been sober for 10 years and was like really proud of their sobriety, and it was a really big, important thing to them, and then they just came up to you at a party and was like, hey, can I have a glass of wine? Then you would be like, whoa, this is a big decision. Are you sure you want to start drinking again? Like, is something wrong? What's up? Right? You wouldn't just give your friend the glass of wine. You'd talk to them about it. Or maybe like an even better example is if you have a friend who's a practicing Muslim who you know has never drank alcohol in their entire life. And they come up to you at a party and they're like, can I have a glass of wine? And then you would be like, is something wrong with you? Like, do you really want to do this? Have you stopped believing in God? That seems really out of character. Like, it seems like you're breaking all of your own rules. It seems inauthentic. So the caveat here is that in order to determine if someone's acting in an inauthentic manner, you have to know them really well, right? Like if some random stranger comes up to you at a party and asks for a glass of wine, you have no idea, right? You're just like, sure, have a glass of wine. But if you have known them for a really long time and you know that they're Muslim or that they're sober, you know it's not an ordinary request. You know it's inauthentic, right? So this is important for the next article when we start thinking about proxy decision makers. In order to understand somebody's authentic decision-making, someone's authentic autonomy is authenticity, requires a deep knowledge of the person, which maybe isn't always available in a healthcare decision-making setting. Okay, so the third sense of autonomy is autonomy as effective deliberation. So the key term here is decision. So that's what that deliberation part means, right? And it needs to be effective. It needs to work. So effective deliberation is about the patient weighing their options and making a decision. So here, the author talks about informed consent again, and he says that we're talking about the informed part of the informed consent. So it's not the consent part, it's not the agreeing, but it's the informed part. It's the weighing of the options and having the information that allows you to do that. So he says on page 24 through 25, so the bottom of 24, top of 25, the doctrine of informed consent, which requires that the patient be informed of the risks and benefits of the proposed treatment and its alternatives, protects the right to autonomy when autonomy is conceived of as effective deliberation. So for deliberation to be effective, it has to be rational and informed. And so the informed part we'll talk about in the future when we get to the question of the informed consent conversation. But it's important to note here that there is plenty of room for prejudice under that rational part. So this is where the critical reading that we talked about from last week kicks in again, right? So historically, men have seen women as irrational. White people have seen people of color as irrational. And in fact, it's really easy to see someone who has different priorities than you as irrational. So, for example, looking back to those example cases that show up in the beginning of the article, you might think that the refusal of the patient who is a Jehovah's Witness to accept blood transfusions is irrational because you don't believe the same things they believe, right? But what our author tells us is that, quote, what makes a weighting or a sort of weighing of the options, a weighting non-rational, what makes a deliberation non-rational is not that it is different from the physician's weighting, so not that it's different from your own decision-making process, but either that the weighting is inconsistent with other values, so that the person's way of making a decision is inconsistent with what you know to be their values. So it's that the weighting is inconsistent with other values that the patient holds, or that there is good evidence that the patient will not persist in the weighting. So that means that it seems clear that they're not going to stay this way forever. So effective deliberation, this is an important part that's like kind of unspoken in the article. Effective deliberation is also final. It means reaching a decision that you won't change your mind about later. And this is because often with medical procedures, you can't. Sometimes you can, but often you can't, right? So the fourth sense of autonomy that appears in this article is autonomy as moral reflection. So you might note the phrase values, attitudes, and life plans sounds a lot like the phrase that we got when we were talking about authenticity, right? Some of those same words appear. So this is moral reflection is actually quite a lot like this question of authenticity, but it doesn't involve the idea of character, a person's character. Instead, it's about asking the big picture questions. So, I'm going to give you guys an example. Say that I've been diagnosed with breast cancer, and I'm deciding, should I get chemotherapy or not? So if I was to ask questions like, should I get chemotherapy? Will it make me live longer? How sick will it make me? Will I lose my hair? Will my insurance pay for it? Those kind of questions, they belong to effective deliberation, right? They belong to that sense of autonomy we just talked about. So they're about autonomy, but they're about autonomy as effective deliberation, asking these sort of practical questions. Moral reflection, on the other hand, is more like, why should I get chemotherapy? Or why should I not get chemotherapy? Is it worth it in the big picture to me? Like, will I be happier? Will my partner be happier? Will my children be happier? Is it right? Is it like morally and ethically right for me to do this? Are there some reasons that maybe I think it's like morally wrong for me to do this? Maybe there's something bad about this that I don't agree with. Maybe lots of people are making money off of this system and I don't like it, right? Maybe it's not actually all it's cracked up to be. So it's asking these really skeptical, really big picture questions. And often they have to do with like death and faith and, questions like, does it matter if I live or I die? Do I get to choose when I die? How will my death affect my loved ones? Those are the big picture moral reflection questions. So in fact, even though it seems like it might, moral reflection doesn't quite mean religious thought, right? So if we look at the example of the Jehovah's Witness, and this is what comes next in the article, moral reflection wouldn't just be the Jehovah's Witness saying, I should not get a transfusion because God says so. But instead, it would be, why does God say that I shouldn't get a transfusion? Do I really believe that I would be denied heaven if I received a blood transfusion? Do I really value life in heaven more than life on earth? Am I sure there is a life in heaven? Is my faith strong enough to withstand the threat of death? So moral reflection is not the same as religious faith. And in some ways it's the opposite. It's about doubt. And it's about asking the kind of questions that faith might, in fact, answer for you. Okay, so the rest of the article is devoted to applying these 4 rules to the cases that showed up at the beginning, these 4 senses of autonomy. And what's worth noting here, one of the important things to note, is that it's not necessary for a patient to satisfy all 4 senses of autonomy in order to have made an autonomous decision. A decision that we as healthcare providers should respect. So 3 out of 4 is basically good enough. And also there's a hierarchy here, right? Moral reflection is usually the one that is way too hard to determine, and it's the one that doesn't seem to matter quite as much, right? So in the case of the patient who has MS from the beginning, right, it's a problem that probably 2 out of 4 and definitely 1 out of 4 are missing, right? And so the big problem is that his decision-making is inauthentic. So it's more important that a decision be made authentically than it is that the patient has proceeded to moral reflection. Okay? So that's one of the big takeaways from this. And sorry guys, I'm looking at my notes here. So the another thing you might note that shows up at the end that'll help us get to the next essay is when the author starts talking about the question of incompetent patients. So if you look on page 27, he writes, "For incompetent patients, the question of honoring refusals of treatment does not arise. It is replaced by the issue of who should make decisions for incompetent patients." So, what we've been talking about this whole time is how to determine if a decision that a patient has made is an autonomous decision, is a decision that we as healthcare providers need to respect and honor. But what happens if a patient is incapable of making a decision? It turns out that the law in the United States attempts to preserve their autonomy, even if they're not there to exert it, even if they're not there to be making these decisions. And the mechanism that we have for doing this is having people who are called surrogates, right? So this gets us to our next article written by Thaddeus Pope, which is called The Legal Fundamentals of Surrogate Decision Making. So you guys should note the abstract. We talked about abstracts last time, right? So the abstract tells you what to focus on. And in this case, it's like a brief summary of the article. It's nice and short. It says what the article is like aiming to argue. And in this case, there are actually a bunch of repeated sentences from the abstract that show up in the opening section. And you guys should know that basically every time someone repeats themselves, especially in a scientific article, that means it's really important. Okay, so the stuff that gets repeated is a good thing to focus on when you're reading. Also, you guys might want to be aware that we're going to be talking more about decision-making capacity next week. So how to determine if a person is capable of making an autonomous decision in the first place. So not just, is this an autonomous decision, but like, is the person at baseline like able to make an autonomous decision? What's important here shows up sort of at the beginning of the article, where Pope talks about decision-making capacity. He tells us that capacity to make decisions is decision-specific, and that incapacity is not a status-based judgment. So, in the first one, that it's decision-specific means that, for example, a patient with fairly advanced dementia is still capable of deciding what they want to eat for breakfast in the morning, but they might not be capable of deciding what long-term care facility they should move into, say. On the other hand, incapacity is not a status-based judgment, sort of on the same hand, means that just because someone is demented doesn't mean they can't make decisions. In fact, someone who is demented is perhaps capable of making decisions, even bigger ones than like what they had for breakfast, because there are all different kinds of dementia and all different levels of it and all different kinds of decisions. So the context really matters here, right? He also notes that in the ICU, the patient almost always lacks capacity. And this seems surprising perhaps at first, but it reminds us that like at baseline, you have to be conscious in order to make your own decisions, okay? So like one of the problems that would prevent you from being an autonomous decision maker is that you're not awake. Is that you're so sick that you're not awake. Other things that can prevent you from being capable of being an autonomous decision maker are delirium or strong medications, or even, if you have a tube down your throat and you can't talk because you're on a mechanical ventilator. But like at baseline, and for our intents and purposes today, like you have to be awake in order to make your own decisions. And what if you're not? What if you're in a car accident and you're unconscious and you're taken to the hospital and you need emergency surgery? Who's going to make that decision? That's what this article is about. So, if we all made these fancy documents called living wills, where we wrote down, when I'm in a car crash and I get taken to the hospital unconscious, this is exactly what I want to happen, technically, you wouldn't need surrogates. But in reality, this doesn't work so well. People don't do this very often, and sometimes you can't even find this document in an emergency situation. And also, like, the living will doesn't anticipate everything simply because we can't know the future, right? It doesn't actually say if I'm in a car crash and like this happens and I need this and this and this, right? It usually is like a vague statement about not wanting to be kept alive by mechanical ventilation, all that kind of good stuff, right? So the fact of the matter is these things are often pretty messy. And that's why this article is pretty involved in listing, he's got this really long, all these long lists of the different kinds of surrogates and why we need them. Okay, so since these living wills don't always work super well, this is why we need these people who are called surrogates. Okay, so there are 5 types of surrogates. And they appear in this article roughly in order of priority, but not quite exactly. So ideally, you want this first kind of surrogate, which is a surrogate formally designated by the patient. But when that's not available, you would go to the second kind, which is a surrogate informally designated by the patient, etc., right? But again, the fact of the matter is that it's pretty messy. So, the first kind, patient-designated surrogates in a formal written manner, right? So the best plan, the best case scenario is that you've got a written document that has been notarized and appropriately witnessed according to state law, which says, I want this person to make my medical decisions when I can't. And this person is called a proxy, or an agent, or an attorney in fact. You don't have to memorize these. They're kind of all the same thing. What's important is that you know what their function is, that they are the person who is legally designated as the surrogate. And that legal document that designates them is called a durable power of attorney, or an advance directive, or other things, depending on what state you're in. But again, you don't have to memorize this. So this is another reading tip. This article is full of words in quotation marks, right? Often single words or phrases like agent or attorney in fact or an advance directive. Sometimes these are quotes from somewhere else, but often they're just words that the author wants to designate as important and specific. So in this case, proxy is the exact word that is used for this sort of thing in certain situations, right? And that's what the quotation marks around it tell you. The quotation marks also tell you, hey, look at this. This is important. Pay attention to this word. So that suggests, sometimes correctly, that these words might be key terms when you're looking out for key terms for our worksheets, right? But they can also be decoys, okay? So you have to read critically. You can't just plop down every word that's in quotation marks. So something like springing, which occurs on page 275, looks important, but if you read through really carefully, it's kind of not, right? It's just like the word that is used for when these people, when the proxy or the agent comes into power, right? When they start doing their thing. So like, it's just kind of a fancy word and it's not doing a lot of work. So keep your eyes peeled for those quotation marks and also try to figure out what the words inside them are doing, what work they're doing for the author in the article. Okay, so it's worth noting that even the formal written patient-designated surrogates are not fail-proof, okay? So let's say I decide that I want all of my healthcare decisions to be made by my friend Ruby. She's my best friend. I want her to make my healthcare decisions. But I'm in a car crash. I turn up unconscious at the hospital. I need emergency surgery, and my dad is there. My dad learns that I'm in the car crash. He shows up at the hospital, right? And Ruby's in Australia. Ruby lives in Australia. So what happens? Who ends up making the decision? Probably my dad, right? Because they can't get a hold of Ruby because it's midnight and she's asleep, right? Or, Australia's on a different time zone. So sometimes it doesn't work. Even the most formal legal designations are sometimes overridden by the sort of facts of the matter on the ground, okay? So moving on. So ideally you still want patient-designated surrogates, right? And the kind of patient, so there's formal written patient-designated surrogates. There are also informal spoken patient-designated surrogates. So just like the second kind of patient-designated surrogate is just like in the first example, just like the kind we were just talking about, except the legal documentation for it is a little bit less formal. So instead of the patient signing a written designation in front of a notary and 2 witnesses, or whatever is required by the specific state law of the state that they're in, the informal kind just involves the patient telling the supervising healthcare provider on their case, in the presence of a witness, who their surrogate is. So the patient says, I want my mother to make my healthcare decisions for me. The physician observes, they tell their physician, the person who's, their primary provider on their case, they say, I want my mother to make my decisions for me. And then there is someone else in the room, anyone else, a nurse, another family member, whatever, and they are the witness. And then the provider writes it in the chart, and the witness signs it. Actually, what happens now with electronic health records is that the witness doesn't sign it, you just write down the witness's name. So the witness part is actually really important, even though the electronic records don't permit signatures. Okay? So the informal version, the patient just tells their provider in the presence of a witness. The third kind that shows up in this article is court-appointed surrogates. So Pope writes, in cases of conflict, this is on page 1076, in cases of conflict among potential surrogates, where no previously designated surrogate is reasonably available, it is sometimes necessary to petition a court to appoint a surrogate. So the important step that's missing here is the part where you try to get everyone to agree. Also missing is the role of social workers. So it's worth knowing that there are people whose job it is to help you sort out these conflicts before you go to the courts or before you make the decision yourself. And if there is any question about who should be making the decisions for the patient, if things seem messy and they're whoa, who knows what's going on, it's probably time to get social work involved. Okay, so the other important takeaway here is that you only go to the courts if there's real trouble, right? So in fact, step 3 is not really step 3 in the order of which you would approach it. It's there because in the sort of legal sense, in the list of who has the right to make the decision, a court-appointed surrogate is the person who has the right above the physician-designated surrogate, which we'll get to next. But going to the courts is expensive and it takes a really long time. And as our author tells us, the entire process can be cumbersome. So this is not the most common type of surrogate. Okay, so the fourth kind of surrogate is a physician-designated surrogate. So you guys will note that 4, the physician-designated kind, often comes before 3 in practice. So like I just said, it's not so easy to get a court-designated surrogate. They come first in order of priority because legally they're more important. Like the list of who becomes president if the president is assassinated. So they're like more important in that sense, but they're actually not more common. They're not the like thing you go to next in your decision-making tree. And so the article states on 1075 that default surrogates are the most numerous type of surrogates. So default surrogates is another way of saying these physician-designated surrogates. So if consensus cannot be reached amongst the family members, even with the help of social work, there are laws in every state that provide a list of who gets to make the decision in a priority order. And it is the supervising provider's job to make sure that the right person gets chosen from that list. So this kind of decision-making, the physician-designated surrogate, according to this legal list, is, you're not going to do this if the patient has said, this is my surrogate, this is who I want to be doing this, right? And you're not going to do this if the patient said, if all of the patient's family agrees that, grandma's brother should be the one to be making these decisions, right? But if nobody can agree and there's no consensus and you're not going to go through all the expense and the difficulty and the time of going to the court, then it's the job of the healthcare provider to decide who gets picked from this list, right? And so the list is different in every state. And the degree to which the provider is bound to follow that list, the degree to which you have to go in that priority order is also different in every state. Okay? So the New York State list, which is probably the one that's most applicable to you guys, goes like this. So the first person who would have priority is a legal guardian, right? So if you're a child, your parents are your legal guardians. They are the ones who have the priority. Also, if you are, if someone has been appointed your legal guardian, or if someone is a court-appointed surrogate, they come first, right? If that person does not exist for whatever reason, because you haven't gone to the courts, because you're not a child, etc., then the person at the top of the list is your spouse or domestic partner. And there are some details on what counts as a domestic partner, and if you really want, you can look them up. I'll link this, the law, in our course materials folder. But so legal guardian and then spouse or domestic partner. And then in the state of New York comes the adult child. So legal guardian, spouse or domestic partner, adult child, and then parent. So note that, children come before parents in this case, but only adult children. And then after parents, brother or sister, and then at the bottom of the list is close friend, okay? And it's the job of the healthcare provider to decide who on this list is the appropriate surrogate. So the best surrogate might not be the person at the top of the list. That's why the rest of the list is there. The ideal surrogate is, according to the US government, quoted by Pope on page 1076, and I learned that it was the government by looking at the footnotes. So the ideal surrogate is, quote, an adult who has exhibited special care and concern for the patient, who is familiar with the patient's personal values, who is reasonably available, and who is willing to serve. So it is the job of the physician to choose the right person from the list based upon their judgment of the surrogate fitting these criteria, right? Someone who has exhibited special care and concern, so someone who actually gives a shit. Someone who is familiar with the patient's personal values, so that's authenticity in the sense of autonomy is authenticity, what we were talking about before. And someone who is reasonably available, so not like my friend Ruby in Australia, someone who's actually there, and someone who's willing to serve, because not everyone is willing to make healthcare decisions about their family members. Okay, so last but not least comes surrogates for unbefriended patients, so patients who haven't got anybody on that list, or anybody that they've managed to designate. So if the patient doesn't have anyone to make decisions on their behalf, you can turn to the courts and get a court-appointed surrogate. But for all the reasons we discussed above, this doesn't always happen, and decisions have to be made. So sometimes healthcare providers end up making the decisions. Also, other professionals involved in the case can sometimes function as surrogates for unbefriended patients. So individuals like social workers, clergy, even ethics committees can function as surrogate decision makers. And again, this varies state by state, depending on the state law as to who should be appointed as a surrogate for an unbefriended patient. Okay, so once you've got the surrogate, regardless of who they are, how should they make their decision? As the surrogate, if you're somebody's surrogate, it's your job to protect the patient's autonomy and to make the choice that they themselves would have made. So how do you figure that out? What are the standards for surrogate decision making? So the first standard, outlined by Pope, is expressed wishes. So he calls this, somewhat confusingly, the subjective standard, but the point is that if the patient said, I don't want to be put on a ventilator, then it's your job as surrogate to make sure they don't get put on a ventilator, okay? And if the patient wrote it down in something like a living will or an advanced care directive, those things we talked about at the beginning, then your job as surrogate becomes the enforcer. It's your job to make sure that the patient follows, that the hospital follows the patient's written wishes, right? So the first standard that you go by, the first set of rules that you follow when you're making the decision is the patient's expressed wishes. Did the patient say something about this? If so, you should follow what they said. The second thing that you do if the patient didn't say anything about this decision, and this is the most common form of surrogate decision making, the second thing that you do is called substituted judgment. So you only do it if the patient didn't say explicitly what they would want in this situation. Substituted judgment means making your best guess based upon knowing the patient. So you try to make the decision that the patient themselves would have made in this situation. So this, thinking back to our first article, you try to make the most authentic choice for them. Okay? You try to preserve their autonomy as authenticity. The third option is best interest. So this occurs if you don't actually know the patient at all, if you're a court-appointed surrogate, or if you're a clergy member who's acting as a surrogate for an unbefriended patient. In a situation where it's actually really hard to know what the patient would have wanted and what their authentic decision would have been. So you go by an idea of acting in the patient's best interest, what decision would produce the best outcome for the patient's well-being. But you only do this if you don't know their expressed wishes and you don't know them well enough to make a decision based on substituted judgment, okay? So best interest actually comes last. So these guys go in order of priority, right? They're applied sequentially. If expressed wishes, then substituted judgment. If not substituted judgment, then best interest. Unfortunately, Pope tells us, surrogates kind of suck. So Pope lists 5 reasons why surrogates are often terrible at their jobs. And this is not one of the important lists for us, so I'm not going to talk too much about it. But what's important to note here is that the things that make a bad surrogate are just the opposite of things that make a good surrogate. So good surrogates are capable of making decisions, they know the patient's preferences and they follow them, and they know what's in the patient's best interest if it gets to that point. And of course, they work together with other family members and friends to establish consensus. Bad surrogates don't know the patient preferences. They might have impaired capacity, so they're not themselves capable of making decisions. They might fail to follow patients' preferences, and they might not even know what the patient's best interests are because they're not knowledgeable enough about the case. And finally, oftentimes, families disagree. Why? Because they do, okay? Surrogates disagree, and that often happens. So basically, surrogates are not that good. But the article says, how do we fix this? The answer, according to Pope, is better communication between clinicians and surrogates. Communication is always important. And if your patient, try to decide things in advance. Very important. And also there are some efforts to teach people how to be good surrogates. So you guys, having studied this in this course, would probably be much better surrogates than the general population. And the additional point that he makes is if a surrogate goes bad, it's the job of the healthcare provider to get a new one. Okay? So it's also worth noting that we get another list of what makes a good surrogate on 1079 under the disagreement paragraph. So it's numbered, so it begins with a set of numbers. The good surrogate knows the patient's wishes. This is a quote. Knows the patient's wishes. 2, knows the patient's best interest. 3, has regular contact with the patient. 4, demonstrates care and concern for the patient. 5, visits the patient regularly. 6, participates in the decision-making process. And 7, is available and willing to serve. Okay, so there are a lot of lists in this article, but they're all kind of trying to get at the big picture of like who gets to be a surrogate and how do you determine who is a good surrogate, who is the best surrogate in this case. So the conclusion of the article is that although there is significant room for improvement, surrogate decision-making remains the best method of safeguarding prospective autonomy. So that means of preserving the patient's autonomy even when the patient can't make decisions on their own. Okay, so that's it for our lecture on autonomy. I know this one ran a little long, so thank you guys for sticking it out. And I look forward to hearing from you on Thursday. And again, if you have any questions, you can send me an email or write them down and bring them to our Q&A session on Thursday. Okay? Take care and be safe.